This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why there is no coverage available to an insured after expiration of his policy, and why insurers, as a result, should avoid suing each other. The United States Court of Appeals for the Ninth Circuit certified to the California Supreme Court the following question for review. Quote, under California's Motor Carriers of Property Permit Act, Vehicle Code Section 34,600 et sec., does a commercial automobile insurance policy continue in full force and effect until the insurer cancels corresponding certificates of insurance on file with the Department of Motor Vehicles, regardless of the insurance policy's stated expiration date? The Supreme Court of California in Allied Premier v. United Financial Casualty Company on July 24, 2023, found that it needed to logically advise the court of its opinion based on the statute and on California precedent. The certified question arose only in the context of claims for equitable contribution and subrogation between two insurers. The court concluded that it bears repeating that the plaintiffs in the underlying lawsuit were compensated to the full limits of Allied's policy under the terms of their settlement, and that at all relevant times, Porras, the trucker, properly maintained an active operating permit. Commercial trucker Jose Porras is a motor carrier of property. Under the Act, a motor carrier cannot operate on public highways without securing a DMV permit, which requires proof of the carrier's financial responsibility. A carrier can satisfy that requirement by obtaining a policy of insurance. If a carrier does so, the insurer must submit a certificate of insurance to the Department of Motor Vehicles as evidence that the protection required under the statute is provided. The Act requires that proof of financial responsibility be continued in effect during the active life of the permit issued to the motor carrier. This requirement prohibits cancellation of a certificate of insurance without notice to the DMV by the insurer. When an insurer gives notice that a certificate will be canceled because the policy will lapse or be terminated, the DMV must suspend the carrier's permit effective on the date of lapse or termination unless the carrier provides evidence of valid insurance coverage pursuant to the Act. United appealed to the Ninth Circuit trying to get another insurer to pay part of the loss, which certified the question of law to the Supreme Court. If the Act requires a commercial auto insurance policy to remain in effect indefinitely until the insurer cancels the certificate of insurance on file with the DMV, then Allied must prevail. If not, United must prevail. Equitable contribution, which is what was being sought in the underlying lawsuit, assumes the existence of two or more valid contracts of insurance covering the particular risk of loss and the particular casualty in question. This assumption lies at the heart of the Ninth Circuit's question. Allied's entitlement to equitable contribution depends on whether United was obligated to indemnify Porras for any damages due to the accident. Allied is entitled to equitable contribution only if it can show that United was a co-obligor who shares liability with Allied for the loss resulting from that event. That is, did both insurers have a policy in effect because of the statute? The Supreme Court concluded that the Act does not extend the policy beyond the term contained in the contract. And as to cancellation of the policy, The Act provided that protection against liability shall be continued in effect during the active life of the trucker's permit, and the policy of insurance or surety bond shall not be cancelable on less than 30 days written notice to the PUC, the Public Utilities Commission, except in the event of cessation of operations as a highway carrier as approved by the PUC. An uncanceled certificate of insurance that remains on file with the DMV does not cause the corresponding insurance policy to remain in effect in perpetuity. But that is not to say that an uncanceled certificate of insurance imposes no obligation of any kind on the responsible insurer. It is true that commercial trucking is a business affecting the public interest and that one goal of the regulating legislation is to ensure that truckers do not improperly seek to reduce costs by carrying inadequate insurance. The Act's legislative history indicates that it was also intended to enhance public safety. The Supreme Court concluded that under an act, a commercial automobile insurance policy does not continue in full force and effect until the insurer cancels a corresponding certificate of insurance on file with the DMV. The duration of the policy's coverage is regulated by its terms and those of any endorsement or amendment to the policy itself. The terms of an insurance contract, therefore, generally determines the duration of the policy's coverage. Although an endorsement can amend a policy, neither the Act nor specific endorsement requires extending coverage beyond the underlying policy's expiration date, and therefore the policy died before the accident, did not exist, and there was no right to contribution. The California Supreme Court, in my opinion, in a Solomon-like decision, read an insurance policy as it was written. Although the statute requires proof of insurance for a trucker to be able to operate on the road, it does not intend to, nor can it, change the wording of any policy. If the legislature wished to change the wording of the policy and eliminate the expiration date to a date to be determined by notice to the DMV, it could have done so. It did not. The expiration date stood, and only the insurer with a policy in effect at the time of the accident was responsible, and it could not force an insurer whose policy had expired by its terms to take on a portion of the liability owed. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog, and you can subscribe to the blog and you'll receive notice of every new blog posting, usually 5 or 6 a week, and you will have access to the more than 4,550 blog postings. You can also subscribe to the videos on rumble.com and on youtube.com, also free. And if you found this blog and the videos to be of use to you or of interest to you, please tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you wish further detailed information about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publications or my local community, where you can receive various articles, blog postings, and webinars on detailed insurance information. Thank you for your attention.